Mic check, 1, 2, 3.
We don't have a court reporter here at this point. As our media person, Brian Lehman, said, we do double record this, both with the video and separately with the web broadcast. Are there any objections to recording it and sending it out to be transcribed instead of having a court reporter present?
Complainants have no objections, Your Honor.
Thank you.
No objection from the company either.
Thank you.
No objection from staff. Thank you, Judge.
Okay, thank you all.
This meeting is being transcribed and summarized.
All right, good afternoon. Today is June 11th of 2026, and the current time is 1:36 p.m. This proceeding is being held in room 310 of the Governor Office Building. The Commission has set aside this time for a motion hearing today in the City of Fulton, Hannibal Board of Public Works, Kirkwood Electric, the City of Marceline, and the City of New Madrid complainants. And do you mind if I call them municipalities?
No objection.
Thank you. Versus Union Electric Company doing business as Ameren, Missouri respondent, and that is case number EC-2026-0156. Now, this case concerns several municipalities' complaint against Ameren, Missouri. The municipalities filed a motion for summary determination or determination on the pleadings, and Ameren, Missouri filed a response and a cross motion for summary determination. My name is John Clark. I'm the regulatory law judge presiding over this hearing today. Obviously, the chair of the commission is on my right, and we currently have Commissioner Mitchell on video participating. And so if they have questions, they will ask those at any time. I'm going to ask council to introduce themselves for the record, starting with the municipalities.
Peggy Whipple of the Healy Law Offices on behalf of the cities of New Madrid, Fulton, Marceline, the Hannibal Board of Public Works, and Kirkwood Electric, and my co-counsel, Jacqueline Whipple of Denton's Law Firm, Kansas City. I think our contact information is a matter of record.
I believe so. Thank you. On behalf of Ameren, Missouri.
Thank you, Judge. I'm Jim Lowry, JBL Law, LLC law firm, and also my associate, Mike Tripp, also of the same law firm on behalf of Ameren, Missouri. And our information is also in the record.
Thank you. And staff did not file any motions that would be at issue here, but for the record.
Thank you, Judge. Travis Pringle on behalf of the staff, and my contact information is also already part of the record.
But I do appreciate you being here if I have questions.
Yep, not a problem, Judge.
The Office of the Public Counsel asked to be excused, and that was granted. Prior to starting, are there any preliminary matters that need to be addressed before we start?
Yes, Your Honor, if I might please, for a matter of clarity of the record, I would have to object that Ameren has not actually cross-moved for summary judgment. Ameren did not file a motion for summary judgment, nor did it file the necessary statements of undisputed material facts. I understand that Ameren is opposing my client's motion, but there is not technically under the commission's rule or the civil rules a cross motion filed by Ameren. And I don't think that affects what we need to do here today, but I didn't want the record to be confused.
So what you're telling me is you believe that Ameren's filing is non-compliant?
I do.
Okay.
It's certainly sufficient to oppose the motion that the municipalities have pending, but is insufficient to stand on its own as a motion for summary judgment.
Okay, Mr. Lowry, would you like to respond?
I disagree, Judge. The Ameren specifically identified, I believe it was one additional material, or maybe it was two, facts that we said that were material and undisputed. And in fact, the cities, and I'm going to refer to them as the cities just for a little less of a mouthful, the cities actually admitted those facts, and we specifically moved for summary determination, and our reply included a memorandum of law that explained why. So I think that we have complied with the commission's rule, and I just disagree with the legal argument conclusion that Ms. Whipple has made. I think we have moved properly, cross-moved for summary determination.
Thank you. There's not going to be a ruling on that now. I'll take that under advisement because I'll certainly need to take a careful look at both motions. Are there any other pending issues I have to deal with prior to this? Okay. I do not think this is going to be an issue, but I always say this anyway. If there is confidential information, please let me know in advance. I may not recognize it as readily as the parties might. If that's the case, let me know and we will go in camera to address that. In terms of the order of argument, the municipalities filed their motion first, so I'm going to let them present argument first. Then I'm going to give Ameren an opportunity to argue their motion. And then I'm going to give each party an opportunity to respond to the others. And that's kind of where I'm going to stop that. It's not going to be a whole bunch of back and forth. Now, there were two, the commission kicked causation and damages out of this simply because those are not aspects of determining whether or not a violation has occurred under the complaint rule. And afterwards, that left us with, did Ameren, Missouri violate its tariff by supplying service to customers without having obtained all necessary permits from governmental and regulatory authorities having jurisdiction? And did Ameren, Missouri violate the Commission's May 21st, 1971 order by failing to comply with applicable air quality control standards of the state of Missouri and or the government of the United States? And I think that boils down to, did they violate their tariff sheet 102, or did they violate the 1971 CCN order? I did want to ask, because in looking back over the complaint, the initial complaint, I noticed that it says, it indicates that there was a violation of the Commission's securitization order in EF 2024-0021, but I didn't see that explained anywhere in there what that violation would be.
Yes, Your Honor, that was part of the pleading because the commission in that securitization order made several findings of fact that incorporated the rulings of the federal court in the Eastern District of Missouri. And it is our position that if Ameren disagreed that it had violated the federal law, as the federal court found, that that would also be a violation of the commission's securitization order. As it turns out, I believe Ameren has admitted that fact. And so, you know, since the complaint is the first document that gets filed in a complaint case, we of course put all the factual allegations in there that we thought might be pertinent, but I don't believe that is in dispute at this point.
Any response?
Judge, all I will say is that Ameren, Missouri very clearly in that securitization case admitted that it had violated the Clean Air Act. The judge so found, the Eighth Circuit agreed with that. So I guess I disagree with the contention that Ameren, Missouri hadn't already clearly admitted that. That's an established fact. It's not relevant to this case, but it's an established fact. And I think what follows from that is, and I made note of this as I was preparing for this hearing, I continue to be a little bit befuddled as to why the cities spent literally half of their reply to our reply to their summary determination motion arguing about whether those findings the commission made in the securitization order were relevant or somehow material to this matter, when what they said was, well, there needed to be evidence that Ameren, Missouri violated the Clean Air Act. Well, that evidence was long ago established, both the securitization case and in the pleadings in this case. So I take Ms. Whipple at her word when she says, I don't think it's an issue anymore, but they've continued to make it an issue, at least through the filings on this summary determination motion. I don't know why, but I agree that it's not an issue.
Your Honor, maybe I could be a little more articulate. It's not at issue because it's not disputed. It is relevant to the case for the public interest, to show why it is in the public interest to grant the summary determination that we've requested. Remember, for this commission, when they grant summary determination, of course they decide, first of all, are there undisputed material facts, and is the movement entitled to judgment as a matter of law? But this commission also goes forward and says to itself, is it in the public interest to go ahead and grant summary determination in this case? all of those allegations, as I have set out by number in my reply brief, they all go to ground the public interest being in favor of summary determination in this case because of Ameren's actions, both in causing the harm that the federal court found that it caused, and this commission acknowledging that the federal court had found that, and this commission even taking into its record part of the transcript of that federal decision, arguing about whether or not Ameren's decisions had been appropriate or not, or reasonable or not. And so that is why those allegations are still relevant to the determination of this case, although they are not disputed by Ameren. They are undisputed facts, but the commission can look at all of those allegations and ground its summary determination to also be in the public interest.
Okay, I follow that. I guess my confusion was, and this doesn't have to be addressed now, my confusion was you can't violate a finding of fact because that's the basis for the commission decision. So I couldn't figure out which of the ordered paragraphs was violated in the commission securitization order. So that's my problem there, is I don't see the cause of action. And so maybe that can get fleshed out at some future point, but.
It's in my reply brief. I list the SUMF, I list them by number, which ones specifically would ground the commission finding that it is in the public interest to grant summary determination. It's in my reply,
Okay,
by number.
okay, but that's just as to the public interest, correct?
I believe that's right. I believe that's where they are relevant.
Okay, thank you. All right.
Judge, may I briefly address that point?
I don't want to go a lot back and forth on this. I don't really know that is a germane issue now, but if you want to take a few seconds, I will let you.
Very briefly, the public interest requirement or the prong of the public interest in the summary determination rule for the commission, I believe, and if you look at the commission's prior decisions, the commission has latitude that a court wouldn't have. If the court finds that the facts are undisputed and there's entitlement to judgment as a matter of law, summary determination or summary judgment must be granted. The court has a public interest gloss on that that says even if we find that, we might not grant summary determination for other reasons, generally that maybe the commission wants to have a hearing on a further matter, but it has nothing to do with, well, the company violated the Clean Air Act and somehow that makes it in the public interest to go ahead and let the city win, which is really the argument I think that's being made here.
Okay, well, I may actually ask you, I have a few questions about public interest, so I may actually ask that while parties are up. Thank you, Mr. Lowry. Why don't we go ahead? Are you ready to present argument? I will let you go ahead and argue your motion.
May it please the commission. I am Peggy Whipple, and together with my co-counsel Jacqueline Whipple, we represent the cities of Fulton, Marceline, New Madrid, the Hannibal Board of Public Works, and Kirkwood Electric. The key undisputed evidence in this complaint case is this commission's previous finding at page 20 of its amended report and order in Ameren's Rush Island securitization case, EF 2024-0021. And that finding, and I'll quote, "A determination that Ameren, Missouri violated the Clean Air Act by not obtaining required permits has already been made by the United States District Court for the Eastern District of Missouri." And Ameren even now, at page 5 of its response, agrees that it did indeed violate that federal law. So these 5 municipal power providers ask this commission now for summary determination of the complaint case by ruling on the 2 issues that the commission declared on April 7th to be within its jurisdiction. In a nutshell, is Ameren's undisputed violation of federal law because it failed to obtain the necessary permits, is it also a violation of Ameren's tariff and its CCN? This should be a straightforward decision made on the plain language of the tariff and the CCN. The tariff sheet that we're looking at in particular is number 102, subsection F. And I'll quote, "In supplying service to customers, Company shall furnish such service within a reasonable length of time, dependent upon the availability of materials, labor, and system capacity, and after all necessary easements, permits, and approvals are obtained from the customer and other governmental and regulatory authorities having jurisdiction. This language is plain that Ameren has an ongoing obligation. The tariff says, in supplying service to customers. An ongoing obligation to obtain all necessary permits from the governmental and regulatory authorities having jurisdiction. Interpreting this duty as ongoing is consistent with the rest of Ameren's tariff. We can take a look at sheet number 96, and I quote, "These rules and regulations on file with the Missouri Public Service Commission contain the provisions under which the company will supply electric service to customers." That's an ongoing obligation. We can also look at tariff sheet number 100, B32. It's the definition of tariff. And I quote, "Documents filed with the commission specifying the lawful rates and other charges, riders and rules and regulations under which the company is required to provide service to its customers." Again, it's present tense and ongoing. But Ameren would have this commission ignore the consistency of the ongoing duty to obtain and possess the necessary permits, the consistency between tariff sheets 96, 100, and 102, and Ameren argues without any citation to statute or case law that its tariff sheet 102 subsection F, that duty to obtain necessary governmental permits, well, it matters only at the moment in time when it signs up a new customer. If you look at Ameren's April 13th opposition, pages 4 to 6, there's no law cited, no statute, no case law for this argument. And if you look at pages 2 to 4 of their May 1st response, again, the argument is not grounded in any statute or case law, it's just argument. Perhaps even more concerning that Ameren would have the commission rule this way without grounding it in statute or case law is what it will do to the regulatory compact. Ameren's argument that it only needs to have the necessary government permits only when it signs up a new customer would annihilate that regulatory compact. That promise is that Ameren must supply safe and adequate service to its customers in exchange for the just and reasonable rate that it charges for the duration of its service to its customers. Let's take a look at the CCN, because it's also very plain language. It included in its ordered language, and I'll quote, "that the authority granted herein shall in no way be construed as authority for waiver of compliance by the applicant," that of course is Ameren, "with any air or water quality control standards now existing or proposed by any agency of the state of Illinois or Missouri or of the government of the United States." Now, it's important to know when you're looking at that CCN order from the 1971 Commission that that ordering language is put into context by a very detailed description in the order itself of the grounds which the commission relied on in order to issue that CCN order. The grounds are set out, and it's verbatim at page 8 of our reply brief. Ameren then promised that commission to ensure that the operation of Rush Island will not adversely affect the air or water quality standards at or near Rush Island, and Ameren promised that commission, when it was getting its CCN, that it would operate the Rush Island plant within all known and proposed standards of the Federal Environmental Protection Agency, as well as the Missouri Air Conservation Commission and the Missouri Water Pollution Board. Ameren even now admits at page 8 of its opposition and at page 5 of its response that yes, the state and federal laws that are cited in that CCN order, they remain applicable, or they remained applicable during Ameren's operation of Rush Island, but Ameren argues here to this commission to defeat this motion that really this commission's authority under 393-170.3 is more limited than it looks like on the statute itself. We know that the statute says this commission has authority, quote, to impose such condition or conditions as it may deem reasonable and necessary. Ameren argues that that's really just a hope or a wish, maybe a suggestion, because Ameren says this commission doesn't have any authority to find that its own CCN order has been violated, even after a federal court has already found that Ameren violated the very law that the commission set forth in the CCN order. In sum, here's what's going to happen to 393-170.3. Ameren's argument is going to add language to that statute if Ameren succeeds here today. The statute, remember, reads right now with no limitation on the commission other than the commission may by its order impose such condition or conditions as it may deem reasonable and necessary. Ameren would add the language, but only so long as the commission has direct and exclusive enforcement authority over such conditions. Now, I don't think anybody in this courtroom believes that anybody here has the authority to amend 393-170.3 in the way that Ameren is basically asking. That, of course, is something only for our legislature to do. And I honestly don't know why they would put that kind of limit on this commission's authority when it considers granting CCNs. And maybe after we filed our reply brief, maybe Ameren decided that maybe it had taken its argument a little bit too far, because in our reply brief, remember, we cited 3 recent CCN orders that came down from this commission: Ameren's own Big Hollow CCN, Grain Belt's CCN for its transmission line, and a recent CCN for Evergy to build a solar facility in the Kansas City area. Every one of those recent CCNs has really detailed conditions requiring compliance with a number of laws that are not directly under the authority of this commission. So Ameren, in its response at page 5, modified its argument a little bit and said, okay, those new CCNs that the commission just ordered that also require compliance with state and federal laws that the commission would not directly enforce, it's okay, those will be obeyed because they are, and I quote, express, detailed, clearly stated, and forward-looking. So now we would have another amendment to 393-170.3. If Ameren is successful here in defeating this motion for summary judgment, 393-170.3 will have another qualifier on it. It will read, the commission may by its order impose such condition or conditions as it may deem reasonable and necessary, only so long as the commission has direct and exclusive enforcement authority over such conditions and such conditions are expressed, detailed, clearly stated, and forward-looking. Ameren's arguments to this commission invite chaos into this regulatory environment. 393-170.3 has been around for a really long time, and nobody has ever tried to add qualifiers on the commission's authority in that section to impose whatever conditions it finds reasonable and necessary. Ameren's inconsistent arguments here would also disrespect the 1971 CCN order of a prior commission, which when you look at the great big long description that I quoted at page 8 of our reply, that commission gave us express, detailed, clearly stated, and forward-looking grounds for the order that it issued. So, in sum, the material facts are undisputed. Ameren violated federal law because it failed to obtain the required permits. The plain language of Ameren's tariff and its CCN required it to comply with federal law and obtain the necessary permits. This commission has always had and still has the authority under 393-170.3 to impose conditions that it finds reasonable and necessary, period. That's all the statute says. This commission therefore has authority here to find when those commissions have been violated. And this commission has authority to enter summary determination in favor of Fulton, Marceline, New Madrid, and the Hannibal Board of Public Works and Kirkwood Electric and their nearly 30,000 Missouri electric customers. It is in the public interest that Ameren, the harm that Ameren caused by violating its CCN and its tariff, be redressed by this commission. It harms the commission to let that kind of harm go unchecked. It certainly harmed these five municipal power providers and their 30,000 electric customers. And I would caution that it would seriously harm the consistent and predictable and reliable nature of our law, our regulatory environment, to insert this kind of chaotic argument into a statute that clearly has no such limitations. Thank you.
Are there any commission questions? Okay, I have a few questions.
Ready.
Let's set the public interest aspect aside for a second and just look at the rest of what the commission has to determine in a summary determination. And I went through and just to briefly summarize, it appears that the facts that are not in dispute are as follows. Ameren, Missouri is a commission-regulated utility engaged in supplying electric service to customers. The municipalities are persons within the meaning of the complaint statute. Sheriff sheet number 2 says what it says, and the 1971 order says what it says. I don't think anybody disagrees on what the actual language is. And then finally, that the United States District Court for the Eastern District of Missouri found Ameren liable for violations of the Clean Air Act by failing to obtain a permit for major modifications at Rush Island. Are any of those defects in dispute between either party?
I believe that they are not in dispute.
Now, outside of the public interest, are those the only facts that are really necessary for a commission determination?
Possibly, yes.
Okay. So, in essence, what this entire summary determination motion turns on is how the commission chooses to interpret language from its prior order and how it chooses to interpret language from its Ameren's tariff sheet. Is that correct?
Yes, Your Honor, and that is exactly my concern, that the commission not be encouraged to interpret it in a way that gives up statutory authority that the commission has and inserts great uncertainty and invites much litigation in the future about what conditions would ever be reasonable and necessary, because would they ever even be enforceable?
Now, the commission's not bound by prior decisions, is it?
No, it is not bound in the stare decisis manner. No, it is not. Now, in my own experience, I have always observed the commission respecting former commission's orders, unless, of course, some law has changed. But I can't imagine that the commission, in its judicial function, would want to undermine its own authority or the authority of a prior commission if it could avoid doing so.
Right. I think current case law gives the commission broad discretion in how it interprets its orders.
Of course.
Obviously, when causation and damages were part of the original complaint, it was easy to understand why it was being brought before the commission. But without those, because the commission cannot determine, damages, and causation is not germane to whether or not a violation has occurred, what's the remedy here if you win?
Yes, Your Honor, very, very good procedural question, of course. The remedy is the decision from the body that has the exclusive primary jurisdiction over the CCN and the tariff. Now, if the commission rules, yes, indeed, those things were violated, I think Your Honor understands, because Mr. Lowry and Your Honor and I at the last hearing already talked about, we understand there will be another phase to this dispute between the parties, but it won't be here, it'll be in a court. And that respects the commission's exclusive primary jurisdiction to have come here first. And that way we don't have a state or a federal judge saying, well, wait a minute, I don't know if I have the authority to make this decision. I think this rests with the commission. And so respectfully, we agreed we needed to come here first.
Okay, so without dancing around it, we're talking about administrative exhaustion.
I guess you could describe it that way, although personally I've always thought I love the term, the exclusive primary jurisdiction of the commission is impressive. I mean, to me it's jurisdiction with capital letters. And so, yes, I will agree with you, but it's a special, important primary jurisdiction. And maybe I feel that way from previous being here. But anyway, yes, very respectful of it.
Now, you requested both summary determination and determination on the pleadings. Would you explain to me how those are different in this case?
Yes, and it really, we argued them in the alternative, and I even numbered the statement of undisputed material facts, trying to make that a little clearer. In our motion, facts 1 through 24 are grounded only in the pleadings, only in the complaint, only in the answer. And if this commission wanted to grant summary determination on the pleadings, then those numbers 1 through 24 will ground that. If, on the other hand, the commission wanted more information or decided that it was just simply more comfortable with a summary determination as opposed to a judgment on the pleadings, we went ahead and provided the undisputed material facts 25 through 32. And many of those are undisputed by operation of various laws, and of course that's all in our brief. But it basically gives the commission the decision to make. Are you most comfortable making the ruling on these two limited issues? Are you most comfortable doing that as determination on the pleadings? If so, you need 1 through 24. If you prefer to go ahead and ground it in a summary determination, then you're welcome to go ahead and use also 25 through 32. Really just to give the commission the option to exercise its jurisdiction in the way it deemed most fit.
In looking at these, I'm going to play devil's advocate probably both ways.
Okay.
In looking at these, starting with the tariff sheet, if you knock out the in supplying service to customers, which I think is key to your argument, but the company shall furnish such service within a reasonable amount of time, dependent upon the availability of materials, labor, and system capacity, and after all necessary easements, permits, and approvals are obtained from the customer and other governmental and regulatory authorities having jurisdiction. It says after, and that seems to imply that the key point is someplace that occurs someplace in the past. And in staff's report, it indicated that it believed that this provision involved initiation of service with the customer. Why is that incorrect?
Respectfully, of course, to staff and to Mr. Pringle, I believe that staff misread the tariff by separating the two phrases of the sentence. Remember, the sentence starts in supplying service to customers. That is both present tense and forward-looking. It is ongoing. Then it says, here's what the company must do. It must provide service within a reasonable time, depending on the availability of materials. But then there's the qualifier, which you said this has to happen first, and after all necessary easements, permits, and approvals have been obtained. Well, if the duty of the company is ongoing, present tense and ongoing, in supplying service, and in the context of the regulatory compact, safe and reliable service for a just and reasonable rate, then absolutely, you can't continue to supply safe and reliable service if you have failed to get all of the permits that you're supposed to have during the time that you're providing the service. Otherwise, I think the regulatory compact is out the window, because how else do you make a utility like Ameren continue to supply safe and adequate service if they're not continuing to comply with all laws that govern them? I don't know how else you get that done.
Okay, that's interesting on a number of levels. I mean, let's take water, for example. You can have clean water running through a pipe to somebody's house, whether or not you've obtained all the permits or not. You know, that service can be safe and adequate, even though you may have not done something that you were required to do. Likewise, it's, when you're talking about violation of the air quality standards under the Clean Air Act, while it's true that was done while providing service, it doesn't seem to be a provision of the safety of the service, if you follow me.
I do, and I think I'll speak to the water example first, because I think it's perfect. It's one that we can see more with our eyes, you know, harder to see electricity, right? Say I'm a new customer, and Ameren Water Company gets whatever permits it has to get, and it tests its water the day before it signs me up, and everything's good. Water's clean, laws are being complied with, necessary permits have been had, so on and so on and so on. And the water starts flowing into my house, and I start using it, and I'm happy. It's still coming. But a week later, an industry up river from me dumps some toxic chemicals into the water, and Ameren Water Company, they're not looking at it because they already signed me up. They don't have any ongoing duty to continue to test the water, to send it in, you know, at any interval of regularity for testing at the lab. I mean, boy, once I'm signed up and they've got my credit card, as long as they keep pouring the water into my house and I keep consuming it, I owe them, even though nobody now knows that the water coming into my house is toxic because Ameren Water Company isn't looking at it. Because, hey, they only had to get that permit when they first signed me up. That obviously is not how any of us receive or supply any of our utilities. You know, water's a great example because it's the one utility that goes into our bodies, right? But all of the utilities are in our homes, and they're around our children and our pets, and every day we all count on the governing bodies, both the Environmental Protection Agency and this body, to make sure that the utilities who are providing, the utility companies who are providing those utilities are continuing to do it safely. That's the regulatory compact. In exchange for that, they get the fairest, most just rate, and I've been here arguing for high rates before, higher rates, raising rates. They fairly get that in exchange for the service that they provide. I mean, that's the deal. And so you can't have Ameren Water Company say, I'm going to keep taking Peggy's money because I'm continuing to pour water into her house and she's drinking it, if they no longer have any duty to regularly make sure the water they're giving me isn't toxic. That's why their argument makes no sense when we're talking about utilities. It just doesn't.
Thank you. Moving on to the 1971 opinion or order, which is somewhat oddly worded. I believe the municipality's argument is that that is a condition that the PSC was imposing upon the utility at that time, and you indicate that that is supported by language within the order.
Yes,
Now, I do not know how, things were done in 1971. I know that.
me neither.
I know that at least currently, when there are conditions, and usually those conditions are proposed by one party or the other, it usually spells out very clearly, that the company is granted a CCN to operate. The company must follow the following conditions, and then those conditions are usually enumerated. So what makes this a condition absent the commission pointing out that it's a condition?
Again, it's a tough question for all of us because none of us were here in '71. I do know from years of looking at prior commission decisions that they have changed over the years. And, some time back, there was even an appellate decision that said the commission reports and orders had to make findings of fact and conclusions of law. The early ones didn't do that. And now, of course, every report and order has numbered findings of fact and conclusions of law, even though the earlier ones did not. So yes, shall we say style has changed, and I would even say it's improved over the years. It is better to have commission orders with numbered findings of fact and conclusions of law and very clearly articulated conditions, no doubt about that. I mean, clarity is always good, right, for everybody, for going forward purposes. What we have here, though, is we have a live, well, it was live until Rush Island closed, okay? Until Rush Island closed, this 1971 order was the single legal authority from this body, from the commission, for Ameren to operate that plant. There wasn't any update or modification or amendment or nothing. This is the legal document which authorized Ameren to operate Rush Island for all the years that it operated Rush Island. So it is the document we must look at when we look at whether or not Ameren's violation of the federal law that the federal court already found, when we look at that and ask ourselves, did Ameren therefore also violate this CCN order? And I think to do justice, knowing that commission decisions have changed in style over the years, I think we have to look at the whole thing, because that's how this legal document was written. I mean, if you notice, the ordered section doesn't even use the word condition, it uses the word ordered, right? But we all know that this is what the commission decided, to tell Ameren, okay, we're going to give you permission to build this Rush Island plant and to operate it over a number of years, and here's what you, Ameren, have promised us, so that we'll give you this CCN order. And that's what they set out in that great big long paragraph. Based on the promises that Ameren gave that 1971 commission, that it would operate it in such a way that it would never harm the air water quality standards and that it would always comply with known and proposed laws of the Federal Environmental Protection Agency, that body of the CCN order absolutely requires a finding that it was a condition.
Thank you. Are there any commission questions at this time? Hearing none, Ameren, are you ready to argue your summary determination motion?
I am, Judge. Thank you. Good afternoon. May it please the commission. The company appreciates the opportunity to be here in person to address this case with you today. Let me lay out the two key issues that relate to our motion. And our motion's just the other, I think it's really just the flip of the coin of their motion. I mean, either they're right or we're right about what the tariff and the CCN order means. But I think, Judge, you were correct. There's really two issues in this case, and they boil down to what's the legal effect of the tariff, what's the legal effect of the CCN, because that's going to determine whether or not there's a violation or not. For convenience, Mr. Tripp, I've asked Mr. Tripp to hand out some documents, and I know you probably have access to these, although I don't think you have access to the last one. The first one is just the attachment to our reply that has sheet numbers 101 and 102, which the cities have admitted were material and undisputed, so that, just for the convenience. The second one is the Rush Island order itself. And the third one are these tariff provisions that the cities brought up for the first time in their reply to our reply, that they now point to and say, well, that shows that our interpretation of sheet 102 is correct. And I just thought it'd be easier if you had those to look at a little bit.
And you're talking about sheet 96 and 100?
That's right, and I think there's a gas tariff also part of that third packet that Mr. Tripp is handing out, because they also cited to a gas tariff. I think it was sheet.
Okay, this is a motion hearing, so these are demonstrative in nature. They're not evidentiary in nature.
Well, two of the three are part of the record already, and the last one are these tariff sheets that, I'll answer your question, yes, I guess so, but the last one were brought up by the cities in their summary determination motion. I guess perhaps I should be objecting to the procedure that they can't inject new facts for the first time in their response, but I didn't. And so since we've already talked about them today, I thought the commission ought to have them in front of them.
Your Honor, if I could just note that there are numerous marks on, I think, each of these demonstratives. I'll call them demonstratives. And for the record, for clarity, I'm going to have to object to the fact that they are marked up. They are not as they would appear in the company's tariff or this commission's records.
I'm not asking them to be made part of the record in any way, Judge. I'm using them so that the commission has a easy tool to follow along with what we're talking about this morning, that's all.
And Ms. Whipple, I assume since you mentioned sheet 96 and 100, you would want us to go back and look at the originals of those sheets, correct?
Yes, and I gave the citations and trusted that the commission would do that.
Okay, I'm going to go ahead and let Mr. Lowry talk, understanding that these are purely demonstrative, and you have pointed out that they have been annotated by the company.
Thank you.
Very well, Judge. So let's talk about the legal effect of the tariff first. To agree with the city's interpretation of the 5 lines that they point to on sheet number 102, and that's section F on sheet number 102, those 5 lines, you have to conclude that the legal effect of section F, starting in 2007 and 2010, when Ameren, Missouri engaged in construction projects at Rush Island and didn't obtain PSD permits. Those are the permits that the major modification permits, Judge, that you spoke of a minute ago. They were called PSD permits. You have to conclude that Ameren, Missouri supplied electric service to all 1.2 million plus of its electric customers in violation of its tariff every day since 2007 and 2010. I didn't misspeak. You have to conclude that if the interpretation of the cities is right. The reason you have to conclude that is that the cities deny that the tariff provision at issue is only applicable at the commencement of service to a customer. In the city's words from their April 13 reply, they say, quote, "In sum, for the duration of time that Ameren supplies service, it is required to have obtained and be in possession of the necessary permits of all jurisdictional, governmental, and regulatory authorities," end quote. And what necessary permits are they referring to? They're referring to PSD permits that Ameren, Missouri did not get in 2007 and 2010. Well, we know that we didn't get the permits, and we also know that since then, Ameren, Missouri has commenced service to and supplied service to countless Ameren, Missouri customers, but it didn't have the permits. So if they're right that having PSD permits, and that's all that matters for purposes of if that's the violation that they're talking about. We didn't have PSD permits back in 2007, 2010. If not having PSD permits was a violation of the tariff, then we have been violating our tariff. We have been violating that tariff the entire time we have been providing service to all of our customers. But no such violation exists because the cities are just plainly wrong. They're plainly wrong because that's not what the tariff says. It does not say what they say it does, and it can't be interpreted as such because such an interpretation leads to the unreasonable, illogical, and absurd result that I just talked about. If the cities were right, then every single Ameren, Missouri customer, all 1.2 million of them, would have standing to come to the commission, file a complaint. They would have had standing for the last 15 or 20 years and ask for what the cities are asking for, to find that Ameren, Missouri violated Section F on page 102, on sheet 102, those 5 lines, when it failed to get those PSD permits. That's the logical conclusion from their argument. The law prevents such an absurd result because you're not to interpret tariffs, which are interpreted like statutes. You're not to interpret them to lead to unreasonable, absurd, or illogical results. As Your Honor alluded to a little while ago, what the tariffs do is they impose on Ameren, Missouri an obligation to, within a reasonable time, supply customers with service. But even that obligation, even that reasonable time clock doesn't start until after Ameren, Missouri has the easements or permits that it needs to what? To supply the service. So Ameren, Missouri might need an easement to hook up, to get to the property. Ameren, Missouri might need to tear up the road or close the road to actually get to the property. It may need a permit from the city to do that. And so those are the kind of permits that we're talking about. Did Ameren, Missouri need a PSD permit to supply service to its customers? No, it didn't. Ameren, Missouri supplied service to all of its customers since 2007 and 2010 without those PSD permits. When somebody came and asked for service, Ameren, Missouri supplied that service. Ameren, Missouri, the necessary permits are necessary permits for them to actually supply the service. People were getting electricity to their houses. People were getting service. People were getting hooked up when they had a new business or a new house. Not having the PSD permit has absolutely nothing to do with whether or not Ameren, Missouri discharged its duty to supply service within a reasonable time. And that's the part that the cities overlook. They discount the key provision of the tariff that talks about the fact that the duty to provide service arises only after a reasonable time has passed once those necessary permits, those actual permits you need to provide service, and they talk about permits that are not necessary to provide the service at all. They may be necessary to comply with the law. In fact, they were. They were clearly necessary to comply with the Clean Air Act, and we didn't get them, and we violated the Clean Air Act for not doing so. But they weren't necessary to provide electric service. Incidentally, and this came up already as well, the staff agrees with the company on this. That is, the staff agrees that what the tariff says is that Ameren, Missouri would violate Section 5 on sheet 102 if it didn't furnish service within a reasonable time. As staff correctly points out, there's no evidence that we haven't done that at all. Whether because of not getting PSD permits 20 years ago or for any other reason. Think about it. If you think about it, it makes sense. No customer, when Rush Island was operated, had a wire straying from Rush Island to their house or their business. Rush Island produces electricity, it gets sold in the Meisel market, customers get electricity from the shared grid. And that happened. Customers didn't lose service when Rush Island was on a planned or a forced outage. Customers didn't lose service when Rush Island had to close. The PSD permits have nothing to do with the company's obligation, which it does have, and it has discharged, and it continues to discharge to provide service to customers. They're conflating two things. Also, the cities ignore the fact that Section F, those 5 lines, they don't exist on an island all by themselves. In fact, Section F follows Section C, D, and E on sheets 101 and 102 that are part of the record in this case. And you can see the obvious relationship between them. Section C on sheet 101 tells the customer, how do I apply for service? Section D on, I think it's on 101 and 102 carrying over, it says, what will my service consist of? Section E says, what will my rate will be? And then you get to Section F, the section that we're talking about, and it says, when am I going to get that service? And what it tells you is you're going to get it within a reasonable time. The cities have no answer at all for the important context that sheets 101 and 102 provide, other than to say, without any support, we were accused a little bit ago of not citing any support or any law for anything, neither did they, without any support, claim that these other tariff provisions somehow contradict Section F, those 5 lines. Well, they don't. You can look at them for themselves. Their point is that those other provisions talk about supplying service and ongoing duty to supply service, and that if the tariff provisions apply to supplying service, then obviously it's all present tense and it's all ongoing. Some tariff provisions apply before service is provided. Perfect example is the application provision. We have an obligation to provide service to all comers, right? But people have to apply for that service, and they're not getting service yet. The provision that says we'll provide the service within a reasonable time. Again, that tariff provision is applying to their request for service, but we're not supplying service yet. And there's other provisions in the tariff that apply after service has ended. For example, how people get their deposit back and things of that nature. So these other tariff provisions that are in that third packet that were brought up by the cities in their reply, they don't in any way contradict our interpretation of Section F. So let's talk about the legal effect of the CCN order. In order to agree with the city's contentions about the CCN order, you have to determine that the commission conditioned the permission it gave the company to construct and operate Rush Island, conditioned it over its entire life to never violate a single environmental law or regulation. And that if Ameren, Missouri were to violate a single law, environmental law or regulation, that would have consequences for the permission that was given. Can't operate, some kind of consequence. That's what a condition is. A condition is either satisfied or a condition fails. And if it's a condition and it fails, there's got to be a consequence for that failure. The cities themselves, and they agreed today, argue that the language that they're pointing to is a condition. I think an examination of the CCN order confirms that the company's and the staff's conclusion that it is not a condition is actually the correct conclusion. On page 3 of the CCN order, above the ordering provisions that Ms. Whipple points to, the commission states its conclusion. And the first one it states, and I think I did mark that on that page, just to draw your eye to it, the commission states that we are going to grant the authority requested herein. In other words, we're going to give you a CCN. The commission does not condition that grant. The commission does not say we're going to grant it, but only if you comply with X, Y, and Z. The commission simply grants it. Then the commission, having discussed above that Ameren proposes to comply with known and proposed environmental regulations, proposed being present tense, so there's known regulations and there's things that are proposed at that time. I mean, there's no way that anybody can say I'm going to comply with every proposed regulation forever. You don't even know if they're going to become law. Then the commission clarifies that no one should interpret the grant that we just made, the CCN we just gave them, as authorizing us to fail to comply. The later ordering provisions simply restate those two conclusions. Nowhere, however, did the commission expressly or impliedly indicate that the CCN authority, the ability to operate, the ability to construct and operate, which is what the CCN gave Ameren, nowhere did the commission suggest in any way that if that commission failed at some point during what turned out to be a 50-year life of Rush Island, that somehow that authority would be no good anymore. The commission didn't say thou shalt not violate an environmental law or will order your plant to be closed. The commission didn't say you are hereby given authority to operate Rush Island, but not if you violate one time an environmental law. Such a condition, frankly, would have collided with the practical reality that exists when you have the situation where a power plant is being operated by human beings over decades. I will judicially admit today that at some point through Rush Island's life, that there was an emissions exceedance, that there was an oil spill that exceeded limits, and things of that nature, because those plants are run by human beings and they have equipment that can fail, and they sometimes do, and those things happen. Surely that didn't mean that the plant was subject to not having permission to operate anymore just because that happened, and I'm sure that it did happen. And if that happens, it's EPA's and DNR's job to impose consequences, not the commission's job, and I think the commission recognized this, to somehow impair the permission, the grant of authority that it gave in 1971. So why did the commission include the shall not be construed language that the cities have latched onto? And I'm going to use staff's word because I think they aptly explained why. And what staff said is, quote, Instead of being a condition, the language appears to be clarifying in nature, assuring that Ameren, Missouri could not make a future argument that because the commission issued it a CACN, it was not required to comply with the relevant air or water controls. I think it's important to keep the context about what was going on in environmental regulation at the time that CCN was ordered. What I think we all think of as sort of the seminal environmental law in the country was the Clean Air Act of 1970. The Clean Air Act of 1970 created the EPA, and it's obviously changed since then quite a bit in certain respects, but it created the basic environmental regulatory scheme that we still have today. It was a very, very big deal at the time. And I think the commission certainly was mindful at that time that a creative utility could very well take the CCN order and argue, and it didn't want that to happen. It didn't want to intrude on the jurisdiction of the EPA or the Missouri Air Conservation Commission. I don't think DNR existed then. I think it was the Air Conservation Commission. Didn't want to intrude on their jurisdiction. So the commission, as staff points out, said, look, we're not intruding on environmental regulation here at all. We're just granting a CCN, giving permission to construct and operate the plant. And I think there's a good analogy for that. We've got another situation, which I'm sure you're probably familiar with. The Federal Power Act, I think, has been around since the 1930s, and ever since there have been a tension going on between the states and the federal government as to where that jurisdictional line has been. And there have absolutely been arguments made about whether state CCNs and other state processes and actions and authority somehow preempts or trumps or intrudes into the operation of the Federal Power Act. And I think, and the reasonable conclusion to draw from what the commission said and the way the commission said it, and that's what staff concluded, is that the commission didn't want to get into that debate and wanted to be very clear. We're giving a CCN. 393.170.1 says if you're going to construct a power plant, you've got to get permission to do it first. That's what we're doing. We are not intruding into, and we're not going to allow Ameren to take our CCN order and somehow make an argument that they can escape application of some environmental law. So I mean, that's it. When you get down to it, for the cities to prevail, they have to make the determinations that I talked about. You have to make those determinations. You have to decide that by not getting PSD permits, we've been violating Sheet 102, Section F, for the last 20 years, and every one of our customers could come in and file a complaint, just like the cities did in this case, and ask you to so find. And you have to decide that the commission wanted to get into the business of conditioning our ability to construct and operate the plant on never once, over what turned out to be a 50-year life, violating any environmental regulation whatsoever. Given that, I think the answer here is pretty clear. Those conclusions are not supported by the tariff language. They're not supported by logic and reason and leading to reasonable results, and therefore the commission's or the city's complaint should fail. Their summary determination motion should be denied. And since it should be denied and there's nothing else left to do in this case at that point, because there aren't any disputed facts, the company's summary determination motion, which would result in an end to the case, should be granted.
Any commission questions? Okay, I've got a few for you. You've touched on some of them already. Why don't we start with the tariff provision where it says company obligations. First of all, you've kind of postulated at the extremes versus the pragmatic, in that, yeah, you know, there are frequently things that are decided that are violations. That doesn't mean the plant gets shut down. That doesn't mean that that's necessarily the remedy or that the CCN gets stripped. All the time, you see this in customer billing complaints where it's determined that there has been some procedure that sometimes accidentally wasn't followed. And usually the outcome of that is not the disgorgement of sums of money or the closing of plants or being told they can't do something. Usually the response is to try and address the violation, which is, in that case, would be like provide X amount of training to the people that are issuing the bills, or something like that. So I think the idea that, that we could suddenly have, that if the commission were to determine this, that a violation had been committed, and then we might suddenly have hundreds of thousands or millions of people come in, I don't think that that's necessarily the case. Even though they might have standing, the issue would have already been determined.
And I just want to clarify, you're talking about the tariff in this instance, not the
These
CCN?
bleed over
Yeah.
in the way that I'm discussing them. I realize that, but there's no real way to talk about them without, if you're talking about the tariff provision or you're talking about the CCN, either way you're talking about a violation. And if the idea is that every day has been a violation since 2007, then I don't see the result where you have hundreds of thousands of people coming in. I think that was the question I asked of the municipalities was, what's the remedy here?
Well, so let me try to unpack that. All that I'm saying is that the logical extension of their interpretation is that because it's ongoing, so if it's an ongoing obligation to supply service after all necessary permits have been obtained, and if a necessary permit includes a PSD permit, and we didn't have one, then that means we were violating that ongoing obligation every single day. Now, I don't literally believe that all 1.2 million customers are going to show up at the commission's door and file a complaint seeking that determination, but they would have just as much right to do that as the cities do. That's sort of a side point. But the point is, if the obligation under Section F, those 5 lines on 102, is supplying service, they're focused on that ongoing supplying, and I don't think that was the best language to use. But you've got to take the entire provision. If you think about when any basic rules of interpretation, you don't take 2 words out of a sentence or a clause or a provision and apply the meaning to that provision just based on those 2 words. You got to look at the entire thing. You also have to look at other items that are relate to the same subject matter, the old impera materia, and I think that's where the context comes in from sheets 101 and 102. But if a PSD permit is a necessary permit, and the cities say that it is, then when we didn't get that PSD permit, we were violating that tariff. That's the only point, and that's not a reasonable reading of the tariff provision. And it also doesn't make sense putting that issue aside. There's 2 reasons it's not a reasonable reading. That's one reason. The other reason is, if you're already providing service, if we've been providing service to Joe Smith for 5 years or 10 years on an ongoing basis, then there is no, that the provision, that the central part of that provision, which gives Ameren, Missouri both a right and a duty to not supply service until a reasonable time has passed, doesn't make any sense. You're already providing service. There's no reasonable time to pass anymore. The purpose of that provision has to be, if you read the entire thing, to allow the company, Joe Smith shows up one day and says, I want service this afternoon, to say, no, I can't provide service this afternoon. Got to get an easement, I got to get a road crossing permit, I've got to get this. And once I have those within a reasonable time, and the commission could resolve disputes about what a reasonable time is if somebody thought Ameren was taking too long, but the company can't instantaneously provide the service. And if you interpret the provision the way the cities are interpreting it, you're just completely ignoring the central part of the provision, and that is this allowance for a reasonable time to provide that service.
I can see that, and one of the issues has been, I'm not fond of the wording of any of these, the way these are done, but when I questioned the municipalities, I said, why isn't the reading the company shall furnish? And that clearly goes into something. Why put in the language in supplying service to customers at all? Why not when starting service or like I said, just begin with the company shall. And it's under a heading that says company obligations. Now, nobody else has submitted anything that implies that there are environmental obligations anywhere else within the tariff.
Well, I'm going to give you a non-legal, a practical answer, and then I'll try to give you one grounded more in legality. At least in my experience, the tariff book is, it's hundreds of pages long, and it is drafted by people who tend to be engineers and tend to be, in the rates and analysis sections of utilities. And those tariffs evolve, and sometimes the most artful language is simply not used. And I don't think that it made sense to say in supply and service, but it also doesn't make sense to read that as an ongoing obligation that says every environmental permit the company needs to operate its utility, even though it doesn't need it to actually, to use your example, get the water to the house or get the electricity to the house, suddenly is a necessary permit. What if it would take 2 years to get an air permit at a power plant that the utility doesn't have? Are we going to have to tell the customer that we can't supply you service for 2 years, even though the wire's there, the capacity's there, we have the ability to deliver the electricity, but we're going to have to get this permit, and it's going to take 2 years to do it, so everybody that wants service has to wait 2 years to get that permit because we don't have some unrelated permit over here that's not necessary to provide service. It's necessary to comply with whatever the permitting authority is that's requiring that permit. I don't dispute that. I don't dispute that we should have had PSD permits, but it's not necessary to supply the service. I also want to take this opportunity also to, to address the water example that you came up with, which I think was a good one. I truly don't understand this argument that if you don't interpret the tariff the way that the cities say that it should be interpreted, that somehow Ameren no longer has an obligation to provide safe and adequate service to all of its customers. 393.130.1 says we do. It doesn't matter what this tariff says. We have an obligation to provide safe and adequate service. The water company in Ms. Whipple's example couldn't just ignore toxicity in the water and allow it to flow through the pipe because this tariff was interpreted as only applying at the commencement of service, because that utility would be violating 393.130.1 from the very beginning. So that's a red herring. The point is, we have a reasonable time to provide service. It only makes sense to read that it applies at the commencement of service, because the temporal nature of it would have no meaning whatsoever. You might as well just take it out of Section F if that's what it means. And we have to get the permits that are needed so we can get the electricity to your meter. That's all we have to do.
Okay, I'm going to skip over to the CCN order for a bit. In looking at the CCN order, the municipalities pointed out that you need to see that order within the larger context of what's said in the body of the order. And in the body of the order, it says the applicant proposes to operate the Rush Island plant within all known and proposed standards of the Federal Environmental Protection Agency as well as the Missouri Air Conservation Commission. Why is the ordered paragraph 2, and it says ordered, why is that not just parroting that? Why, if that simply says, they say if the body of it simply says, the applicant says they're going to follow all environmental rules, past and future, which is a possible reading of proposed.
Understand.
Then why isn't the ordered paragraph just parroting that as a condition? You said you're going to do it. It is a condition that you do it.
Well, you might note that, and Ms. Whipple took umbrage to my doing this, you might note I actually bracketed the exact same language you just read in the body of the order, because I think it actually supports our argument. Again, you have to put this in context. The EPA had just been formed 5 months earlier. The EPA, I'm sure,
I'm going to stop you real quick. Is any of this in the pleadings, or is this just background context you're giving me now?
It's background context, but I think you can certainly take notice of it.
I don't know that I can in a summary determination. I'm going to let you go with it for now.
Well, you can make the decision, and I can't say that I've researched it or can give you a completely cogent argument as to why you can or you can't. But regardless, there were undoubtedly maybe some existing regulations and probably a whole bunch of proposed ones at that time. And I think the reading in context of what existing and proposed meant here are the regulations that are on the table. They're coming down the pike. We propose to comply with those. The way we've designed, there was discussion of where the coal was going to come from and that at some point scrubbers might have to be put on the plant. All of that is in the order, by the way, that we would have to comply. And is it possible? Is it possible to turn all of that into a condition? I mean, anything's possible. But the commission didn't say that it was imposing a condition. And I'm going to go back to, and I think you mentioned this a minute ago, I think violation of an order and a condition are not the same thing. And the reason is, and I'm going to go back all the way to law school and take you back there with me a minute. A condition has a specified meaning, right? And a commissions are either satisfied or they fail. And if they fail, what does that mean? If you're conditioning the grant of something, what does that mean? I will absolutely allow you that if the commission, if there are regulations and so on, and somebody violates a commission order and so on, that there can be remedies, like the commission can ask the general counsel to go to the circuit court and seek fines and penalties. That's always a remedy the commission has. But the conditions that can be imposed, and Ms. Whipple spent a lot of time talking about an apocalyptic world where we're just going to completely blow up 393-170 if any of our arguments are accepted. And I don't subscribe to that. I'm not going to go into that right now. But the conditions that can be imposed under 393-170.3, which is obviously part of the CCN statute, they're conditions on the grant. The grant is you are hereby allowed to construct and then commence operation of this plant. I would argue that 393-170.3 isn't actually a 50 or 75 year operating permit. It's permission to construct, and obviously you're going to construct, you're going to actually, when the thing goes into service, you're going to start putting coal in the boiler and it's going to start operating. But I would argue that 393-170.1 isn't some ongoing, forever operating permit necessarily that the utility gets, because when you read the statute, it doesn't say you must come in and get permission to construct and to operate. It says you must get in prior to commencing construction. You shall come in and get the permission and authority of the commission, and we call that a CCN. CCN's not actually used in the statute directly, but that's what we call a CCN.
Maybe I'm not following you here. Are you saying that the commission can only order conditions that are finite?
I think I'm saying two things. I think if the commission, no, I don't think that's true, because I think there's other sources of authority that the commission has. In 393-140, one of the commission can prescribe such facilities as are safe and adequate and those kinds of things. I think there's some other authority. So I think the commission can order some ongoing conditions. But what I don't think the commission can do is order conditions that are not within the purview of its express or implied statutory powers. And I'm not saying the commission has never purported to do that. I think it's very rare. If we look at the orders that Ms. Whipple cites in her reply, the Big Hollow order, the Grain Belt order, the Evergy order, if you look at those, provide construction reports, give us an update on the permits you needed. I don't remember the other two or three. They are all conditions where the commission's saying, I'm giving you permission to construct this thing, and necessarily I know once you construct it, you're going to turn it on and start using it. I want to know how the construction's going. I want to make sure you have all the permits you needed in connection with that construction before you start operating it. Because if you think back to the South Harper litigation, and these are court cases that exist and that you can obviously look at, but the commission doesn't want utilities going out, getting CCNs, constructing power plants and not getting all the permits they need and so on to actually start up that power plant, and then have a big mess on the commission's hands where the utility maybe has $1 billion power plant that they now have problems with. And I suppose the commission can try to protect ratepayers from the financial consequences of that, but damages the utility's credit, damages the utility's financial standing, and it creates a big mess. So the commission imposes a number of conditions. It's very common for that to happen on what evidence the utility has to provide. And those do stop when the plant is in service and operating. And those are, I would say, 90% of the commissions we see out of CCN cases. They are finite. I think occasionally commission goes beyond that, and under other statutory authority probably has the authority to do that. But I think where the commission crosses the line, if it goes beyond that and it purports to get into areas that it doesn't have express or implied statutory authority for.
Well, I think it's interesting. I'm glad you brought that up, because that was an argument that you made in your pleadings that I didn't quite follow. And that was that the commission did not have authority to impose conditions involving the Clean Air Act, basically because that's not in our yard. However, I didn't follow your argument because I don't think that it would be the commission making that determination as whether the Clean Air Act was violated. I think what you're postulating is kind of bizarre in that it would be, are we making the determination that they violated? I would assume that it would come kind of the way this came, which is another court has made that determination, and now it's in front of us as an undisputed fact. Do you follow me? So I don't get your argument that the commission could not impose a condition that you follow other laws.
Well, let me try to articulate it a little bit better. If the utility comes and gets a certificate from the commission that says you can construct and then start up and operate this plant, then it's done what it needs to do as far as the commission is concerned in order to do that. The commission can impose conditions under 393-170.3. But I don't believe the ability to impose conditions is unlimited. The commission can't say, just to take a far-fetched example, and you shall always have this many employees from the state of Missouri, employed by your utility, or some other example. The commission's a body of limited jurisdiction. I think we all recognize and agree with that. And to know what authority the commission has, you have to look at what's expressly in Chapter 386 or 393, or you have to say, what are some other powers that are necessarily implied, the commission has to have them in order to discharge the authority that it was given in those two chapters. And requiring compliance with environmental laws, which is already required by the EPA and any other state or federal laws or statutes, it's not necessary for the commission to require that in order for the commission to do its job to discharge every single authority that it has. It's certainly not expressed in any statute that the commission has that authority, and there's no implied reason, there's no implied power that needs to exist for you to do your job for that environmental compliance. And let me take it a step further. Let's imagine utilities don't comply with the environmental laws, and it causes problems, and it causes financial losses or other impacts, right? If that happens, if utility imprudently doesn't follow those laws and that causes costs and so on, you have every bit of authority and jurisdiction you need to protect customers, because you can in the rate-making process not allow the utility to recover those. The utility gets fined by the EPA $10 million, you don't have to allow recovery of that. Utility imprudently does something else that's in violation of environmental laws, and that has that impact, you don't have to allow recovery of that. And that's your regulatory authority. But your regulatory authority is not to tell the commission, you've got to comply with all these things over here that somebody else, that the General Assembly or the Congress has already delegated to somebody else. The commission's sort of unique in some respects in that it only has the powers the legislature gave it. As I think you've probably know this, the commission's been called a committee of the legislature because all of its power comes from the legislature. There's no constitutional basis. The legislature, in theory, could just regulate utilities directly and not have a commission. And so if you don't have that power, then you can't do it. And so I do think that you can't get into conditions that go beyond your statutory authority, whether it's expressed, and you won't find any expressed authority for this. And I don't think you can find any necessity to have the authority to do that either, to exercise those express powers. That is the argument.
Well, to kind of play devil's advocate again, I believe, and I'm not quoting this exactly, so bear with me. I believe the CCN statute authorizes the commission to impose such conditions as it finds necessary, which doesn't seem to be much of a limitation. And on the flip side of that, I don't think the EPA has any authority to grant a CCN. So I think that those two dovetail without necessarily crossing. You had said, and I found this interesting, you know, in the tariff, they've said this, but there was really no reason to. We have to comply with these laws federally anyway. So whether it's said in the tariff or not, it's something we have to do. And when I go to this 1971 order and I go to paragraph 2, if it's not a condition, then it seems like what the commission is doing there is merely pointing out the limitations of its own authority, which seems something very odd for the commission to order.
I will allow you that it's an unusual provision. I cannot argue with you, Judge, and that's why I pointed out that the ordering provisions are nothing more than a replication of the conclusions that the commission had in the conclusion section of the order, which aren't technically the ordering provisions. And so I think, and Ms. Whipple said it, and I'd say too, I was 7 years old in 1971, so I can't say exactly what all the practice was at that time. But I think you have to give effect to the way the commission structured this order. And they included this conclusion, and I think staff hit the nail on the head. They simply were doing just what you said. They were saying, look, we can't tell you, you can't take our order and use it as a get-out-of-jail-free card for compliance with environmental laws. And we want to be clear about that. And then they repeated that language in an ordering provision. And I think that's what happened here. None of us were there, and you have the unenviable job of having to make a decision about it, obviously. But I think how this order is structured is important, and I think it supports, while it may be unusual, it's not something we would see today. I think it supports the conclusion that we reached and that the staff, as independently of us, also reached.
Okay, thank you. Are there any commissioner questions at this point? Hearing none, I was going to give each party an opportunity to do a brief rebuttal. If you would like to go ahead, municipalities.
Briefly, Your Honor, responding to one of Mr. Lowry's admissions, because I think maybe it will kind of help us cut through to the chase here. Mr. Lowry admits that the federal court has already concluded that Ameren violated the Clean Air Act every day for all the years that it operated without the required permit. There's no dispute about that. So, of course, for the same duration of time, Ameren violated its tariff and its CCN, because the tariff and the CCN required Ameren to have been in possession of all required permits of all governmental authorities for every day that Ameren violated the Clean Air Act, according to the federal court's decision, it also, every single one of those days, violated its tariff and its CCN. That is not an absurd result. That is simply an undisputed fact. Ameren doesn't like the fact, and I guess I can understand why they don't, but it's still the truth. But it's not, it doesn't, the consequence of that, as the court had, as Your Honor and the commission has already specified in the two issues that it has articulated it will rule upon, the consequence of Ameren's violation does not land here. The decision to be made here by this commission, who has exclusive primary jurisdiction over the CCN and the tariff, is, was the CCN violated by Ameren's violation of the Clean Air Act by not obtaining the required permits? Was the tariff violated by Ameren's violation of the Clean Air Act by not obtaining the required permits? Period. The consequences will be sorted in a court. And that's also why this dispute won't come before this commission by anybody else, not Ameren's millions of customers or any other cities or anything like that, because once that decision is made here, yes, the tariff was violated, yes, the CCN was violated, that decision is done. And anybody, I don't know of anybody that has the same harm that our 5 municipal power providers suffered. I don't know of any, but if there are any out there, they're not going to come here again and relitigate all of this before the commission, because the commission will have already made that decision. And so it's final here with the decision on these two issues. And whatever consequences come to Ameren, if any, for that, are in a court, not here. The other thing I wanted to say is I wanted to comment, add to Judge Clark, you asked about the significance of Tariff Sheet 102, Section F, which is clearly labeled company obligations. And there isn't another, I looked, I promise, there isn't another section in the tariff that spells out the company obligations. This is it. And I know that Mr. Lowry said, well, hey, you know, the reason that it starts off with, the very first thing that's said in that section, in supplying service to customers, Mr. Lowry said, well, you know, hey, these tariffs, they're written by technical people and engineers, and, you know, maybe, you know, it could have been better worded. Well, I think if we asked any engineer in this building or any technical person in this building, if you ask my husband, who's an engineer, if an engineer wrote those words in supplying service to a customer, by golly, that's what he meant. He meant anytime you supply customers with service, by golly, you better do all the things that follow in this paragraph, because that's how precise and specific technical people and engineers are. So I would go back to just what I said when I first stood up here. The decision here is straightforward. We already know it's undisputed that Ameren violated the Clean Air Act because it didn't obtain and possess all of the required governmental permits while it supplied service through its Rush Island plant. The question is, look, the language in the tariff and the language in the CCN both say you've got to have permits. So the question is, did they violate the CCN and the tariff while they were violating the federal law? And the answer is yes. And we're done. It's just that straightforward. The facts are undisputed. The law is clean. It can be determination on the pleadings. It can be summary determination at the commission's comfort level. And we move on to another forum. And I thank you on behalf of the 5 municipal power providers and all of their customers for hearing this today. Thank you.
Thank you. Ameren?
Briefly, let's go back to the fundamental problem with the tariff argument, because there's different arguments that have been made and so on. The temporal nature of the language in the tariff requirement is completely nonsensical and doesn't even belong there if the city's argument is true. Because if we've got we're already providing service and the service is already ongoing, there's no supplying service within a reasonable time. That's the central part of the provision. You've got to read the entire provision together. And if you don't do that, then that provision really has no meaning. Secondly, just because we need a permit to do something over here, I mean, our truck drivers need CDLs, but I don't think we're going to argue that that's a necessary permit prerequisite to, surely we're not, providing our customer service. Or in the example I gave before, what if we find out we need a permit from something and it's going to take 2 years to get one? Do we have to tell all of our applicants that we can't serve them because we don't have that permit yet? That can't be what necessary permits means there, particularly when you inject the temporal nature of the language that says we both have sort of some protection. We don't have to provide the service instantaneously, but we also have an obligation. We can't just sit on our hands and not provide within a reasonable time. We have to provide within a reasonable time. That's the key operative language in the tariff, and that's, I think, is what we're missing. The other thing I think I'll say about that is, before when you were asking Ms. Whipple questions, we got into this water example. We had this pretty long and convoluted discussion about, well, if the tariff doesn't mean what we say it means, where's Ameren's obligation? Ameren doesn't have an obligation to provide service on an ongoing basis. Well, as I said before, that's just not true. It's not what the provision means, and Ameren does have an obligation under 393.130.1. We don't need to put it in the tariff to repeat it. And in fact, I think it's very clear that, to me, Ms. Whipple says very clear to her, the law is straightforward, the facts are straightforward. If the law was as straightforward, I think we wouldn't have spent nearly as much time on the cases we have. But I do think that the proper and best reading of the tariff is the one that we've advanced to you. Staff has agreed with that. The party that, of course, is looking for you to find a violation and to get to court so they can, under some theory, bring civil action against us, of course, sees it differently, and I understand that. I guess I'll make one other point only, and because you and I just talked about most of these questions, and I think in our discussion we really hit on most of the things that I was going to address that Ms. Whipple had to say. But one other thing that came up, if the CCN, and I guess this goes back to the tariff, if the CCN, as I think has been suggested today, is the sole authority to operate the plant, then the tariff would become irrelevant. This idea that we have to have a necessary permit in the tariff, and the tariff somehow creates an ongoing obligation to allow us to, or the tariff is the source of our ongoing obligation, wouldn't be necessary. So with that, I also very much appreciate the fact that you had questions, and I hope that we've been able to illuminate those questions. Appreciate your patience in addressing them this afternoon, and I'd ask you to find in favor of the company on its cross motion. Thank you.
Thank you, Ameren. Now, I have ignored you, staff, this entire time because you have not filed a summary determination motion of any kind. But I don't want to prevent you from weighing in if you have something you want to say. However, I'm not requiring you to say anything.
Staff, for the most part, we're present here just in case the commission had any questions about our recommendation, but really nothing further for us that staff has to say about either motion for summary determination. But thank you, Judge.
Thank you, Mr. Pringle. Is there anything else that needs to be addressed before we adjourn this hearing? All right, I'd like to thank you both for your time coming here today, and staff included. And I appreciate you taking the time to put together some very cogent arguments for the commission to consider. And with that, I will adjourn this motion hearing, and we will go off the record.